Hello, friends. Every year, the Social Security Administration sends out millions of decision letters. Letters about benefit amounts, eligibility determinations, overpayment notices, and disability decisions. And buried inside every single one of those letters is a deadline that most people never notice. 60 days. That is the window you have to challenge a decision you believe is wrong. Miss that window and the decision becomes permanent. The SSA does not send a reminder. They do not call to check whether you saw the letter. The clock starts the day the letter is mailed, not the day you read it. And when it runs out, your right to appeal goes with it. What makes this particularly difficult for seniors is that SSA decision letters are not easy to read. They are long, they are written in bureaucratic language, and the most important information, the deadline, the appeal rights, the specific steps to take, is often buried toward the end where most people never get to it. Today, I am going to lay out everything clearly, what the appeal process actually looks like, what your rights are at every stage, what most people get wrong when they try to navigate this on their own, and what gives you the strongest possible chance of getting a decision reversed. If you have received any kind of letter from the SSA recently, stay with me. This applies directly to you. Let us start with the deadline itself, because there is a detail about it that catches almost everyone off guard. When the SSA says you have 60 days to appeal, most people assume that means 60 days from the day they receive the letter. It does not. Technically, the 60-day clock starts from the date the letter was mailed. The SSA assumes you received the letter 5 days after it was sent. So in practice, you have 65 days from the mailing date printed on the letter, not from the day it arrived in your mailbox, and certainly not from the day you got around to reading it. This distinction matters more than it might seem. If a letter sat on your kitchen counter for 2 weeks before you opened it, you have already used up a significant portion of your appeal window without knowing it. If the letter was delayed in the mail, forwarded from an old address, or simply overlooked during a busy or stressful period, the clock was still running the entire time. There is a provision for requesting a deadline extension. If you can demonstrate good cause, meaning a genuine reason why you were unable to file within the 60-day window, the SSA can grant additional time. Good cause includes things like a serious illness, a death in the family, receiving incorrect information from the SSA itself, or not receiving the notice at all due to a mail issue. But good cause is not automatic. You have to request it, explain the reason in writing, and the SSA makes the determination. It is far better to file within the original window than to rely on an extension. The practical takeaway is this. Anytime you receive a letter from the Social Security Administration, look at the date printed on the letter immediately, count forward 65 days, and write that date somewhere visible. That is your deadline. Everything else can wait. That date cannot. Before getting into how the appeal process works, it is worth being clear about what types of SSA decisions can actually be appealed, because many people assume appeals are only for disability denials. That is not the case. You can appeal virtually any formal decision the SSA makes that affects your benefits or your eligibility. This includes a denial of retirement benefits, a reduction in your monthly benefit amount, a determination that you were overpaid and owe money back to the SSA, a denial of spousal or survivor benefits, a decision about your disability status, a determination that you are no longer eligible for supplemental security income, and a decision about when your benefits should begin. Overpayment notices deserve particular attention here because they are among the most common SSA letters seniors receive in 2026 and among the most misunderstood. If the SSA sends you a letter saying you were overpaid and must repay a certain amount, that determination is itself a formal decision that can be appealed. You can challenge whether the overpayment actually occurred, whether the amount is correct, and whether repayment would cause you financial hardship. You can also request a waiver of the overpayment entirely if you were not at fault for the error, and repaying it would cause hardship. Both the appeal and the waiver request have their own deadlines and their own processes, and both are worth knowing about if you receive an overpayment notice. The Social Security appeals process has 4 distinct levels. Each one is a separate step with its own procedures and its own timeline. Understanding all 4 matters because where you start and how far you go depends on your specific situation. The first level is reconsideration. This is where every appeal begins. You submit a request asking the SSA to have someone who was not involved in the original decision take a fresh look at your case. For many non-disability decisions, benefit amounts, eligibility determinations, overpayment disputes, reconsideration involves a review of your file and a new written determination. For disability cases, reconsideration typically involves a new medical review. The reconsideration process does not involve a hearing, it is a paper review, and statistically, it results in a reversal less often than the levels that follow. But it is a required step. You cannot skip it and go directly to the next level. The second level is a hearing before an administrative law judge. This is where the appeal process becomes significantly more powerful. An administrative law judge, called an ALJ, is an independent SSA official who reviews your case from scratch. You have the right to appear in person, present your evidence, bring witnesses, and make your case directly. The judge can ask questions and request additional information. ALJ hearings result in favorable decisions at a substantially higher rate than reconsideration reviews. For disability cases in particular, getting to this level with proper documentation and representation makes a dramatic difference in outcomes. The third level is a review by the Appeals Council. If the ALJ hearing does not result in a favorable decision, you can request that the SSA's Appeals Council review the judge's decision. The Appeals Council can affirm the decision, modify it, reverse it entirely, or send the case back to an ALJ for another hearing. This level is more limited in scope than an ALJ hearing. The Appeals Council typically focuses on whether the judge applied the law correctly, rather than re-evaluating all of the evidence from scratch. But it is a meaningful step and an important one to take before moving to the final level. The fourth and final level is federal court. If the Appeals Council denies your request for review or issues a decision you still disagree with, you have the right to file a civil lawsuit in a United States District Court. Federal court review focuses on whether the SSA's decision was supported by substantial evidence and whether the correct legal standards were applied. This level involves legal proceedings that virtually always require an attorney, but it exists, and for people with strong cases who have been denied at every administrative level, it is a real option. There are several mistakes that come up repeatedly in SSA appeals, and knowing them in advance significantly improves your chances of a favorable outcome. The first and most common mistake is waiting too long to start. People receive a decision letter, feel overwhelmed by it, and put it aside. Weeks pass. By the time they are ready to act, the window is gone or nearly gone. The moment you receive any formal decision letter from the SSA, your first action should be to note the deadline. Everything else follows from there. The second mistake is filing an appeal without understanding what you are actually disputing. A strong appeal is specific. It identifies exactly which part of the SSA's decision you believe is wrong and explains precisely why. A vague statement that you disagree with the decision carries very little weight. A clearly articulated argument that identifies the specific error, incorrect earnings record, wrong benefit calculation, failure to consider relevant medical evidence, gives the reviewer something concrete to evaluate. The third mistake is not submitting supporting documentation. Whatever your appeal involves, evidence matters. If you are disputing a benefit calculation, bring your earnings records and your Social Security statement. If you are challenging a disability denial, bring medical records, doctor's letters, and documentation of how your condition affects your daily functioning. If you are contesting an overpayment, bring bank statements, payment records, and any correspondence with the SSA that is relevant to the timeline. Evidence does not guarantee a reversal, but the absence of evidence almost guarantees a denial. The fourth mistake is going through the process alone when free help is available. Many people assume that getting help with an SSA appeal requires hiring an expensive attorney. That is not always true. Organizations like the National Organization of Social Security Claimants Representatives, called NOSSCR, can connect you with representatives who specialize in SSA appeals. Legal aid organizations in most areas provide free assistance to seniors with SSA disputes, and for disability cases specifically, many attorneys work on a contingency basis, meaning they only get paid if you win, and the fee is capped by federal law at 25% of back pay up to a maximum of $7,200. You pay nothing up front. The mechanics of filing an appeal are more straightforward than most people expect. The SSA provides specific forms for each level of the process and multiple ways to submit them. To request reconsideration, you file Form SSA 561, Request for Reconsideration. For disability cases, there is a separate form, SSA 3441 Disability Report Appeal, which documents any changes in your medical condition since the original decision. Both forms are available at ssa.gov or at any local SSA office. To request an ALJ hearing, you file Form HA-501, Request for Hearing by Administrative Law Judge. This form can also be submitted online through your My Social Security account at ssa.gov, by mail, or in person at your local SSA office. To request Appeals Council review, you file Form HA-520, Request for Review of Hearing Decision. All of these forms require you to identify the decision you are appealing, explain why you disagree, and provide your contact information. None of them require legal language or complex arguments at the point of filing. The detailed argument comes later, at the hearing stage, or in written submissions to the Appeals Council. One more thing worth knowing. Filing an appeal does not automatically stop your current benefits from changing if the SSA has notified you of a reduction or termination. In some cases, you can request that your current benefit level continue while the appeal is pending. This is called continuation of benefits, and it applies in specific situations, primarily disability cases where benefits are being terminated. Ask the SSA directly whether continuation of benefits applies to your situation when you file your appeal. Let us bring it all together. Every formal SSA decision comes with a 60-day appeal window that begins from the date the letter was mailed, not the date you received or read it. In practice, that gives you approximately 65 days from the mailing date. The moment you receive any SSA decision letter, identify that date and write it down immediately. You can appeal virtually any SSA decision: benefit denials, benefit reductions, overpayment determinations, disability decisions, and eligibility rulings. The appeal process has 4 levels: reconsideration, ALJ hearing, Appeals Council review, and federal court. Each level is more powerful than the last, and each requires its own filing. The most common mistakes are waiting too long, filing without a specific argument, submitting without supporting documentation, and trying to navigate the process alone when free help is available. Organizations like NOSSCR and local legal aid offices provide free or low-cost assistance to seniors with SSA appeals. The forms you need are available at ssa.gov. Form SSA 561 for reconsideration, Form HA 501 for an ALJ hearing, Form HA 520 for Appeals Council review. And if you miss the 60-day window, you can request an extension by demonstrating good cause in writing to the SSA. If this video gave you something useful, please subscribe and turn on the bell. SSA decisions affect your income, your health care, and your financial security, and the rules around challenging those decisions are not something the SSA goes out of its way to explain clearly. What I do on this channel is take exactly this kind of information and put it in plain language before the deadlines pass and before the options close. Subscribe so you always know what you are entitled to and what to do about it. And if you know someone who has recently received a letter from Social Security and is not sure what to do next, share this video with them right now. That 60-day window does not wait. I will see you in the next one.